Hello friends, today I'm going to tell you a little bit how former NBA player and superstar Dwyane Wade from the Miami Heat had a huge impact on family law cases here in Miami-Dade County. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so I was inspired to create this video because about 2 weeks ago, I had a chance to go back home to Chicago. I have a close buddy who's having a baby for the first time, and I have been selected to be the godfather, so I went to the baby shower. It was awesome, and as I was sitting there, I got to thinking about how it's such a great sports town and how a lot of athletes have come out of Chicago. It got me to thinking of Dwyane Wade, also known as D. Wade. He is from the south side of Chicago, although he spent the majority of his 16-year NBA career playing for the Miami Heat, where he is the all-time leader in points scored, games, assists, steals, a whole bunch of stuff. He's won 3 NBA championships, and recently it has been announced that he will be inducted into the Basketball Hall of Fame. In addition to that, Dwyane Wade has very significant philanthropic pursuits, including the Wade's World Foundation, which is a foundation that provides support for at-risk youth. He has been involved in the Alonzo Mourning Foundation. When there were earthquakes in Haiti a couple years back, he was instrumental in providing a lot of financial support for Haiti. And Dwyane Wade is a huge supporter of St. Jude's Children's Research Hospital. But the point of this broadcast is that he actually married his high school sweetheart. And in 2008, D. Wade filed for divorce in Cook County. The divorce finally was granted in 2010, and he was actually given custody of the children that he had with his first spouse. What's interesting is that in 2013, he was having some issues with his former spouse, and he filed an emergency motion in court in Miami-Dade County to have the mother of his children's time sharing suspended or to have her submit to a psychological evaluation. According to the court filings and the appellate docket, because this case eventually was appealed, some of the behaviors that the mother was engaging in, including that she fired her attorney, that she would sit outside the courthouse with a sign saying how the Miami Heat superstar had left the mother of his children on the street, and Dwyane Wade felt that because of this behavior she may do something drastic, so he was a little bit scared for the safety of his kids. Went to court, he filed a motion to suspend, and the court denied the motion to suspend. However, the court ordered the mother to get a psychological evaluation and participate in the child's therapy. Pending the evaluation, Dwyane Wade was granted full custody of the children, and he was allowed to stay in Florida with the children. The mother's attorney then appealed it to the 3rd District Court in Miami-Dade County. On appeal, the 3rd District Court reversed the trial court's ruling and said that the mother did not have to get a psychological evaluation because her mental health was not in controversy. The appellate court then reiterated the rule, which there has to be 2 prerequisites in order for a party to have to submit to a mental health evaluation. The first is that the opposing party's mental health condition is in controversy, and the second is that good cause must be shown. According to the appellate court in Wade versus Wade, a parent's mental state is in controversy when it is directly involved in a material element of the cause of action or defense. So where do we find this? Well, there has to be allegations of the mental health being in controversy either in the divorce petition or the paternity petition or in subsequent motions. Examples of what type of behavior may be considered in controversy in order to at least meet the first prong of the Wade standard would be perhaps when a parent neglects or abuses a child. Another example may be if the parent is causing harm to themselves. Another example is perhaps the parent caused harm to another person. Perhaps they were arrested for being violent with another person. If a parent was involuntarily hospitalized because of mental health issues. If a person who suffers from mental health abruptly stops taking their psychotropic or their prescribed medication, that could also put their mental health in controversy. Now we're getting to some of the stuff that is relevant given the current state of social media. If there are social media posts that exhibit erratic behavior or some sort of unstable behavior, that is something that may place parents' mental health in controversy. Remember, we've done videos before and we've said, be careful what you put on social media. Be careful what you put on social media. And finally, another example, just to give a last example, is either messages or videos that you are sending to your soon-to-be ex or the opposing party. If you're sending either videos that are foreboding of like violence or abusive, that's a problem. Your mental health is going to be in controversy. Simply because because you have satisfied prong of the parent's mental health being in controversy, it doesn't mean that you are done. That does not stop the analysis. The second part is there has to be good cause shown for a psychological evaluation. Good cause has to be based on evidence that the parent is unable to meet the needs of the child because of their mental health issues. Once you have been able to demonstrate that the mental health is in controversy, how do you show good cause? Remember that when a court ultimately determines a time-sharing schedule in Florida, they are considering the factors set forth in Florida Statute 61.13. Within that statutory framework is where you will find some of the good cause necessary to meet the second requirement of the Wade case and the ability to have a psychological evaluation of an opposing party. A great example is the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent relationship with the other parent. If the parent who has mental health issues is unable to encourage and foster a relationship between the minor child and the other parent because of those mental health issues, you may have demonstrated good cause. Also, part of that same factor is whether or not the parents will honor the time-sharing schedule. Well, if the parent's mental health condition doesn't allow them to honor the time-sharing schedule, you may have also been able to demonstrate good cause. The anticipated division of parental responsibility. If the parent's mental health illness prohibit them from engaging in parental responsibility, as in co-parenting, or it prohibits them from communicating with the other parent, that may be a problem, that may be good cause. Another example is the capacity and the disposition of each parent to consider and act upon the needs of the child as opposed to the needs or desires of themselves. Is the parent that is suffering from these mental health illnesses unable to focus their attention and care for the child when they have the child? One of the other factors is the length of time the child has lived in a stable, satisfactory environment. If the parent's mental health issues have not allowed for there to be a stable environment, that may be a good cause. The statute spells it out specifically. It says the mental health of the parents. However, remember that that is not enough. It has to affect the child. And finally, one of the ones that I find usually one of the main ways that good cause can be shown is if the parents don't protect the children from litigation. There's hardly anything else that courts do not like more. In other words, courts do not like when the parents are telling the children about the litigation. And if they keep getting told by the court not to do it, and their mental health issues do not allow them to compartmentalize and not involve the children in the litigation, this is something that could be good cause for the court to order a psychological evaluation. So that's a wrap on how Dwyane Wade's case has left an indelible mark on family court cases here in Miami-Dade County. His case has helped guide a lot of practitioners, including myself, on how to file motions for psychological evaluation. So congratulations to Dwyane Wade on his soon-to-be induction to the Hall of Fame and on his many philanthropic accomplishments. I am a big admirer. I'm a big fan. I love the fact that he's a Chicago guy, and the Heat are doing really well this year. So congratulations to you, sir. For those of you who are dealing with these mental health issues in your cases and may need some advice, you can look us up at www.segarralawfirm.com. We have offices located in Miami and Orlando, Florida. Se habla español. And please do us a favor and subscribe to the Divorce Broadcast. Like this video and share it with anybody that you think this information may be helpful to. And hats off to Dwyane Wade.